When terminating an employee, a general protections claim is the most dangerous and problematic to defend. Terminating the employment of a staff member is never a pleasant ordeal. Most of the time, employers and managers would have had a gut feeling or knew a lot earlier they wouldn't work out. In the end, firing an employee can be very messy. Most employers are concerned about unfair dismissal claims. However, general protections matters are by far the most dangerous claims. Hi, my name is Jonathan Mamaril, Principal and Director with MB Lawyers, Lawyers for Employers. When an employee is terminated, there are usually 4 avenues to sue an employer: filing an unfair dismissal claim, claiming discrimination under state or federal legislation, a breach of a common law contract, or a general protections claim. But what is a general protections claim? A general protections claim can take many shapes and forms. However, the most common one is when an employee claims that their employer has taken adverse action against them, such as terminating their employment or demotion for exercising a workplace right, such as making a complaint regarding their pay or requesting flexibility for work hours. In our experience, we are seeing more of our clients deal with general protections claims, and there are a few reasons for this. The first major one is that there is a reverse onus of proof. Namely, in general protections matters, an employer is presumed guilty until they can disprove otherwise. This can be quite difficult to do, and clear evidence from the key decision maker will need to explain that the reason for why the adverse action, the firing for example, was taken for a reason other than a prohibited one. That is, it wasn't done because of a query for an employee regarding the wages, because they are female, the employee is getting older, or because they are a union member. Secondly, although compensation can be awarded in these matters, penalties can also be awarded of up to $63,000, and more significantly, an individual involved in the breach can be liable for up to $12,600. Now this is the scary thing. Directors, managers, HR consultants, advisors, and even accountants and CFOs can be held liable for being in breach of a general protections provision. Also remember, in general protections claims, employees can make a claim whilst they are still employed. Some quick tips for employers to deal with general protections claims. 1. Be clear about the reasons for dismissal and ensure they are not muddied. Is it in relation to redundancy, misconduct, or underperformance? A process should be undertaken for each of these types of dismissals. If an employee brings a claim, they'll be tested on these reasons. 2. Prepare evidence to support the reasons. Keep contemporaneous notes of the reason provided and any other documentation to support this. 3. Test the evidence. For example, if the employee was dismissed for misconduct, was a show cause letter provided to them? Was there an investigation that occurred reporting on the alleged misconduct? 4. Does the employer have evidence to rebut any claim for breach of a workplace right? 5. If the matter proceeds to court, keep in mind the evidence of the key decision maker will be tested. So keep to a minimum the number of key decision makers involved in the process. If you'd like to know more about unfair dismissal, general protections, and redundancy, visit our website at www.lawyersforemployers.com.au or contact us on 07 3876 5111.